Welcome, everybody. Welcome to the Law of Self-Defense show for today, which is Friday, July 29th, the last show of July 2022 for Law of Self-Defense, unless we do something over the weekend. Always possible, but it's less likely than usual, folks, because I was a couple minutes late to the show today because I just got back from signing a lease for the new Law of Self-Defense office space. So the last time I expect you'll see this background behind me for one of our live shows is today. Next time we do a live show, I expect it to be in our new office, and it may take us a few days to get that all fully built out. The wall behind me may be bare for a few days for the first few shows from the new office, but we'll get it done as quickly as possible. Hopefully the audio was good. Turns out all that was required was to reboot my soundboard. Who knew? So we could have gone ahead with the show yesterday if I'd known to do simply that, but I didn't. So we know, good for next time. So yes, signed the lease on the new Law Self-Defense office space, still staying in Castle Rock, Colorado, and took Miss Emily out to lunch to celebrate. And we were a little bit delayed getting back, but we are here now. And we are here today to talk about shooting at a fleeing aggressor, firing shots at someone running away from you, and whether or not they can ever be legally justified. Before I proceed, I want to mention, I suppose, for those of you new here, I am Attorney Andrew Branca for Law of Self-Defense. Wow, that is amazing. I can't tell you how much I appreciate that. That's fantastic. And of course, our sponsor for today's show is, once again, Law of Self-Defense itself. And that's our free book. Our free book, The Law of Self-Defense Principles. It's a real physical book, folks, 200 some pages. You can buy this book on Amazon. In fact, I encourage you to go to Amazon to take a look at it, because you'll see over 1,000 reviews, solid 5-star rated book. But don't buy it there. If you buy it there, they charge you $25 for the book, plus shipping and handling. I will give you the book for free. I'll eat the $25. I do ask you to cover the shipping and handling, unless I guess you want to come to Castle Rock, Colorado and pick it up from our brand new office. Then there is no shipping and handling. But if you would like the book mailed to you, we have warehouse people we have to pay, and U.S. Postal Service and so forth. So there is a shipping and handling charge. But the book is free. The $25 book is free. And you can get this free book at lawofselfdefense.com/free book. And folks, if you're not willing to even get a free book to make you informed on when you can lawfully use force, especially deadly force, in defense of yourself, your family, your property, I'm not sure there's anything anybody can do for you. So, but it's up to you. This book available to you for free at lawofselfdefense.com/free book. Also, over the course of today's show, if you would like to ask questions, I am happy to answer questions over the course of today's show. And it appears we're streaming correctly on all. Well, let's see. I got to check. Let's see. YouTube's working. Law Self-Defense member dashboard is working. Is Rumble working? That damn Rumble. It is. So you can watch today's show on any of those platforms. If you're a Law Self-Defense member, I would encourage you to... Well, that's an interesting problem. So it's streaming there on Law of Self-Defense. I don't, however, see the Law of Self-Defense specific chat. So let's see if we can get Miss Emily on the line to help us. Emily, on the Law of Self-Defense member dashboard, we're streaming today's show, but there's no chat visible to me.
I'll check it.
Okay. Love you. Bye. All right. She'll check it. Meanwhile, on YouTube, you can, of course, chat. But if you want me to answer the question, it needs to be in the form of a super chat. And we'll answer those either throughout the show or before the end of the show for what it's worth. For your Law of Self-Defense members, I'm watching the show on that stream, but there is a glitch where I can't see the chat. So what can I say? It's technology. We are streaming live on YouTube and Rumble. Either one of those is lawofselfdefense.com/YouTube or lawofselfdefense.com/Rumble. There you go. So shooting at someone who is fleeing. That's the topic of today's conversation. Can you ever do that? Can that ever be lawful? And the general answer is that it won't be lawful. Under whatever scenario you're thinking of, it probably won't be lawful, but it could be if it meets specific conditions. Really, the same conditions that would apply to justify any use of defensive force against another person, any use of force against another person as a defense of self, defense of others, defense of property, legal justification. But the prospects for those conditions being met if the person you're shooting at is in flight are much reduced. What you definitely cannot do is shoot at them in flight because you would have been or were privileged to shoot at them earlier. So the mere fact that the conditions were met for the use of deadly defensive force earlier in an encounter does not mean that those conditions are checked off forever. That's the element of imminence in a justification legal defense. The 5 elements of self-defense, the 5 elements of defense of others: innocence, imminence, proportionality, avoidance, and reasonableness. Imminence has to do with the requirement that for you to be justified in your use of force, the threat you're defending against has to be either actually in progress, which is difficult to have happening if the other person's in flight, or immediately about to occur, which is also difficult to have happen. Did I successfully mute that, or did you hear all the curse words? But I believe for Law Self-Defense members, I believe the stream is now working in the chat as well. So for those of you on YouTube, if you want your questions here answered, they have to be in super chat form. If you're a Law Self-Defense member, please do that at the Law Self-Defense member dashboard, and we'll prioritize your questions there. You're already members. There's no need for you to be paying to get your questions answered. You get your questions answered simply for being Law Self-Defense members. All right. So we have a couple of cases in the news recently. One was out of Houston. Let me see if I can pull that one up. There's a little bit of a video clip here. Good heavens. I thought I had that prepared. Here, I think I do. Let me just upload it to StreamYard here. It's not super informative, but I know you guys love your videos, so we will, let me upload this Houston video. This is a woman in Houston armed with a pistol. There was apparently some road rage event already taking place in progress when this video starts. The other car appears to drive away, be fleeing the scene, and the woman fires her gun at the departing vehicle as it's racing away. So let's take a quick look at that video here. And I think when I play this, it will obscure me off the screen, but the video only lasts for a few seconds. So here we go with this Houston woman firing at a vehicle in flight video.
Oh. Oh my God. What the?
Okay, and that's the video. So she fired kind of haphazardly at least one shot at the other vehicle as it was departing. And I know I'm going to get plenty of booty comments in the chat. I'm just going to ignore those folks. So she fired a shot at that car as it was departing. Could that ever be legally justified? And by the way, if it's not legally justified, we have any number of criminal charges that could result, right? I don't expect she actually hit any of the people in that vehicle, but if she did and she lacked justification, it could be murder, it could be manslaughter if they're killed. If they're not killed, if they're just struck by the round, it could be battery, aggravated battery with a firearm, good for 10 to 20 years in prison. If they're only in fear of being hit, they know they're being shot at, even if they're not actually struck by a round, aggravated assault with a firearm, good for 10 to 20 years. Also, this is not out on the open ocean. There's apparently a car dealership back there with a building. People are likely to be in the building this time of day. So she's firing around, and rounds don't miss, right? They might miss your intended target, but they don't miss everything. They keep going until they hit something. And so firing a gun in an environment like that almost certainly qualifies as felony reckless endangerment to a level of death or serious bodily injury. Even if the person in danger doesn't know they're in danger, even if you don't actually cause any injury, it's still endangerment. That's reckless, especially with a firearm, unless you can justify it on some legal basis. So the question becomes, well, can you justify it on some legal basis? And what would be the possible legal justifications? Well, one might be self-defense, in which case you'd have to show that the people you're firing your gun at presented as an imminent deadly force threat to you. Another might be defense of others. Maybe they didn't present as a deadly force threat to you, but they did to others in the vicinity. And this would have to be in the immediate vicinity, foreseeable risk of death or serious bodily injury to others, not speculative. Not, well, for all I know, they'd get on the freeway and run over a bus full of nuns. That's not what would qualify. There'd have to be some evidence from which you could make a reasonable inference that there was an imminent threat actually occurring or immediately about to occur to others. That could be a defense of others justification. There could, in theory, be a defense of property justification in Texas under Texas Penal Code 9.42. Texas is the only state in the country that has a legal provision for the use of deadly defensive force in defense of property. It's a lot of conditions in that statute. And by the way, if you'd like to read that statute, you can find it at lawofselfdefense.com/942. It comes up so often, we have a shortcut link to the statute. Lots of conditions, lots of hoops, lots of reasonableness requirements in that statute. And reasonableness is not determined by you, folks. At least not the reasonableness that determines your legal fate. Your legal fate is determined by the perception of reasonableness of other people, the police, the prosecutor, the judge, the jury. It's what they decide was reasonable, not what you thought was reasonable in the moment. And in that defense of property statute, deadly force in defense of property statute under Texas Penal Code 9.42, there's also requirements, hoops like time of day requirements. So some of the conditions that trigger the privilege to use deadly force in defense of mere personal property in the absence of a threat to persons, which is not allowed in any other state. But some of those conditions under Texas law are things like time of day. It says in the nighttime. Well, what's the nighttime? First of all, it varies from day to day over the course of the year, right? But is dusk included? Is dawn included? We don't know. The statute doesn't say. So that becomes another judgment call by other people. So I always caution, even if you're in Texas, be very wary of that deadly force in defense of property statute, because if you don't qualify and you killed someone and you lack that justification, well, that's just a murder or manslaughter, and you're going to prison for a very, very long time. And again, it's not your perceptions of what was reasonable or whether it was time of night or all the other conditions that controls your legal fate. It's the perceptions and decisions of other people who may not have your interest at heart. So those are some of the things where we can consider defense of self, defense of others, defense of property, and I'll circle back to those in a moment. I did want to share with you one concrete example illustrating how the fact that you may have been privileged to use deadly force earlier in the confrontation, and let's say if you had used deadly force earlier in the confrontation, it would have been completely lawful, doesn't mean that you're now infinitely privileged to use deadly force forever. against that person. The element of imminence requires that before you can use, and let's limit ourselves to deadly defensive force for the context of the show, before you're privileged to use deadly defensive force, you have to be facing a threat that's imminent, either actually in progress, you're taking the beating, or immediately about to occur. The fist is pulled back. It can't be a threat that's already occurred in the past, and it can't be a threat that's speculatively in the future. So someone says to you, you know what? You're an a-hole, and I'm going to go home and get a gun and come back here and shoot you. Well, if they come back with a gun, they may be presenting as an imminent threat. But at the moment they're telling you that, in that moment, they're not an imminent threat. And the law expects you to do other things to secure your safety other than simply shooting that person in the face, like calling the police, leaving the area, because the law recognizes that most people who make those kinds of threats do not, in fact, come back with a gun, do not, in fact, ever become an imminent deadly force threat. And it wasn't necessary ultimately to kill that human being. So the threat can't be a speculative one in the future, and it can't be something that happened in the past. So things that happened in the past that may have qualified as an imminent threat in the moment may no longer exist as an imminent threat. So the window of eminence, eminence can be thought of, the element of eminence, as a window. It opens and it closes. Until it's open, you're not privileged to use deadly force in self-defense. So that would be the speculative future threat that may or may not ever actually be realized. Once it does open, well, then you're facing an imminent threat. And assuming that the other elements of self-defense are also checked off, you would be in a position where you're privileged to use deadly force in self-defense. But then the window of eminence can also close. The threat resolves. And if you continue or initiate the use of deadly defensive force after the window of eminence is closed, well, then you're no longer responding to an imminent threat. And your earlier use of force, if there was an earlier use of force, may have been perfectly lawful, but that later use of force, once the window of eminence is closed, is no longer lawful. So you may be in the clear for the first few shots you fired earlier in the confrontation and have 100% criminal liability for the later shots you fired after that window of eminence had closed, after you were no longer facing an imminent deadly force threat. Of course, because I am who I am, I completely forgot. Folks, if you're watching this on YouTube and you're looking at the screen and you see a big red subscribe button, folks, pound that subscribe button, beat it until it's gray. The most important thing you can do for us on these free live shows is become a subscriber on the channel. That most effectively convinces the YouTube algorithm to share our content more broadly. It's free, doesn't cost you a penny. If that subscribe button is red, it needs to be gray. Click it until it's gray. Hit that bell so you're notified. Maybe, you know how YouTube is, maybe you're notified of our future content on our YouTube channel. And if you subscribed in the past, believe it or not, YouTube may have unsubscribed you. So please, if you see it's red, smash that button until it's gray. If you're here, presumably it's because you like our content. Guess what? YouTube has a button just for that purpose. It looks like this. Okay, hit that thumbs like hit that thumbs up like button, and in the chat YouTube tracks something called engagement, which is when people leave comments. So please leave a comment in the chat, even if it's just your city and state. Some of you cleverly say this is just a comment to fool the YouTube algorithm. Awesome, do that if that's all you have to say. I really appreciate it. But subscribe, like, comment. You know, I believe Nick is still suspended from his YouTube channel, Nick Requeta Law. It's ridiculous that they've done this, of course, but that's what YouTube is like. So, you know, if you're not cheating, you're not fighting fair, right? So help me fool that YouTube algorithm by subscribing, liking, leaving something in the chat, even if it's just your city and state. That's much appreciated. All right, little sip of coffee for me. Okay, so there's a case out of Florida a few years ago. Michael Dunn. Michael Dunn, now in prison for the rest of his life in Florida. So ultimately, things did not work out well for Michael Dunn. Wow. You. But let me tell you the story about Michael Dunn. And then I have some video of Michael Dunn and some crime scene photos of the Michael Dunn shooting that illustrates the point I want to share with all of you now. And that is that this is an example of a case where multiple shots were fired by Michael Dunn. And his first few shots were actually did not result in a conviction by the jury, even though those shots actually killed somebody. So when Michael Dunn was in his trial, and he had multiple trials, but let's talk about his first trial. When he was in his first trial, he was on trial for murder and attempted murder. Murder because he shot and killed a young black man. Attempted murder because he shot at several other young black men. Didn't hit any of them, but he was charged with attempted murder for having shot at them. He was not found guilty in his first trial of the actual killing on the murder charge. But then he fired additional shots, the attempted murder shots, and he was found guilty of multiple counts of attempted murder. So his first shots, the jury in his first trial argued or concluded that the state had not disproven his legal defense of self-defense for those first few shots. But they decided to treat the later shots much differently, even though they were all within 6 seconds of each other. The later shots, 6 seconds later, those were enough to convict beyond a reasonable doubt on 3 counts of attempted murder, which under Florida law was 20 years, 20 years, 20 years served consecutively. So that's 60 years in prison. At the time, Michael Dunn, when he was on trial and the shooting, he was, I believe, in his mid-40s. So trial, he was looking at getting out at 105 years of age. What's unusual about the Michael Dunn trial is we have video and audio and forensics evidence that lets us definitively attach each set of shots fired by Michael Dunn to a particular physical outcome and to a particular criminal charge based on that physical outcome. So we have a very robust understanding of when shots were fired, what their real-world physical consequences were, what the criminal charges were based on those consequences, and what the jury verdict was based on those criminal charges, and therefore based on the consequences of when the shots were fired. So we have a degree of clarity in this case. That's unusual, which makes it worth sharing. So a little backstory on the Michael Dunn case. So Michael Dunn, white male in his mid-40s, I believe. And he was in the company of his fiance, a white woman. We'll see her in the video coming up in a moment. And they had just finished attending a nearby wedding of Michael Dunn's son. So Michael Dunn's son had gotten married. They were at the wedding. The wedding was now over. This was in Florida, in the Jacksonville, Florida area, so on the east coast of the state. And Michael Dunn actually, although he was in the Jacksonville area for the wedding, he lived a couple of hours away. So he had driven in a couple of hours for the wedding. Now they were at the wedding. The wedding was over, and they were going to stay in Jacksonville at a hotel and drive back home in the morning. Makes perfect sense, right? But they've left the wedding. They're on their way to the hotel for the night, and they stop at a gas station, convenience store, to pick up some supplies for the hotel. So Michael Dunn pulls into the parking lot, pulls right up against the curb in front of the glass windows of the convenience store. I'm sure you're all familiar with the setup. And he waits in the car as his fiance goes inside to buy some stuff. The video we'll see is the security video of from the convenience store of Michael Dunn's fiance interacting with the clerk at the counter inside the convenience store. She's in the store. She's buying a bottle of wine, and she's buying what looks like a bag of potato chips, and she's just waiting to check out when the excitement happens. And the excitement is that while Michael Dunn is seated in the driver's seat of his car waiting for his fiance to come out, a SUV, a red SUV, pulls up in the spot next to him, immediately on his left, outside his driver's side door. And inside that vehicle are 4 young black men out to have some fun that evening. In the rear passenger seat is Jordan Davis. Jordan Davis would be the what the law calls the victim here. He would be killed within the next few minutes by gunfire by Michael Dunn. The other three gentlemen in the SUV would not be injured by Michael Dunn's fire, but he would shoot at them. So Michael Dunn would ultimately be facing a charge of murder for the killing of Jordan Davis and 3 counts of attempted murder for firing shots at the 3 other gentlemen later on in the confrontation. So this SUV pulls in next to Michael Dunn, and apparently it was playing rap music very, very loud. Window shaking loud was the testimony at trial. And of course, this is the point of engagement where the parties disagree about what happened. So Michael Dunn testified. He actually testified on his own behalf at trial, very unsympathetically, by the way, which is another reason defense lawyers don't like their clients to testify, because sometimes they look like dicks on the witness stand, and that's not at all helpful. I watched Michael Dunn's testimony, and he was 150% dick on the witness stand. Arrogant, self-assured, contemptuous. Basically, he was Amber Heard, except facing a murder charge instead of a defamation charge. Completely unlikable character on the witness stand. But he would testify in the witness stand that he politely asked these 4 young black men to turn down their rap music, and they pointed a gun at him. Specifically, Jordan Davis, the young black man who would be killed, pointed a shotgun-like weapon at Michael Dunn. So what did Michael Dunn do then? Well, he was armed with a Taurus 9mm pistol. It was the copy of the, I guess the Beretta, whatever it is, the Beretta 92. He had the Taurus version. I guess he got the Taurus pistol that actually works because his gun actually did fire. But he didn't have it on his person, unfortunately. He had it in the glove box of his car. So he had to lean over to the glove box, opened it, grabbed the Taurus pistol out of the glove box, turned over his shoulder, basically, because remember, he's in the driver's seat of his car. He's pointing kind of backwards now to the rear passenger seat of the SUV and fires rounds at Jordan Davis. Those 9mm rounds proved extremely effective. I don't mean to diminish the death of Jordan Davis here, but just speaking clinically in terms of terminal ballistics, those 9mm rounds penetrated both sides of the door, the outside and the inside, and fully penetrated Jordan Davis, mortally wounding him. He would live for a few more minutes, but if he'd been on an operating table, nobody could have saved him. 3 rounds entered him and caused mortal injuries. And the moment after those shots were fired, that SUV decided it was getting the heck out of there. So it starts backing out of its parking space, does kind of a J-turn behind Michael Dunn's vehicle, and drives off, fleeing the scene. So what does Michael Dunn do then? Well, he actually gets out of his car, takes a knee in the parking lot, and fires more rounds at the SUV as it's driving away. So essentially, we have 2 sets of fire here. I believe it was a total of 10 rounds fired. We'll hear in a moment. We have the first 3, pop, pop, pop. Those are the rounds that would kill Jordan Davis. Almost immediately, we have another 4 rounds. These are fired as the SUV is starting to back out of its space. Pop, 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 pop. For our purposes, we'll treat that as one group of fire. Then we have a pause. And that pause is occurring while the SUV is doing its J-turn and starting the race away, and Michael Dunn's getting out of his car and taking a knee in the parking lot. That's all happening during the pause. And then we hear 3 more shots. 3 more shots fired at that SUV as it's fleeing the scene. And as we'll see, the jury ultimately treated the first rounds fired very differently than they did the last rounds fired. The last rounds fired at the fleeing SUV. So let me share with you now the video. So the video is not video of the shooting. This convenience store, as many convenience stores these days, they did not have security cameras outside the store. In the old days, it was actually more common to have security cameras outside the store to capture vehicles who were taking gas and running off without paying. But today, these days, at most gas stations, you largely have to prepay for the gas. So many of them don't bother with cameras outside. They often have cameras inside for robbery purposes or shoplifting purposes or whatever. And this convenience store did. It had a camera inside. So the camera's looking at the clerk. We'll see the clerk behind the counter. We'll see Michael Dunn's fiance buying her wine and chips. And the nice thing about this camera is it had not just video capability, but audio capability. So we don't have video of Michael Dunn firing his gun. We don't have video of the shooting, but we have audio of the shooting. So we can hear the sequence of shots as they're fired. That pop, 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 pop. Then the pause. Then pop, pop, pop. So. And because of the forensics evidence, we can attach the physical outcome of each series of shots with the result that occurred, and therefore with the criminal charges that were attached to each result. And therefore, we can assign the jury's verdicts or lack of verdicts to each sequence of shots, which is what we'll do now. So let me see if I can, first I'll pull up the video itself. Now, I did pull this video. This is a topic I talk about in our full day law of self-defense advanced course. So I've pulled it off the PowerPoint presentation there. Hopefully it works correctly. So I'm going to play it now. What we'll hear, we'll see on the left, we'll see a counter in a convenience store. We'll see a black woman on the left. She's the clerk in the store. We'll see Michael Dunn's fiance on the right, a white woman. She's there to buy her wine and her chips. And we'll start hearing the gunshots. Pop, 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 pop. And then a long pause. And then the last three shots. Pop, pop, pop. Fired as the SUV was driving away. So here we go.
Oh my God, somebody's shooting. Somebody's shooting out their car. I swear to God.
So, oh my God, someone's shooting outside their car. Oh my God. All right, so I'm going to play that video again, but I really want you to pay attention just to the last couple seconds. All right, look at the clerk in the last couple seconds and look at Michael Dunn's fiance in the last couple seconds and contrast their response to gunshots being fired on the other side of a glass window, only a few feet from them. And by the way, all those shots were definitely fired by Michael Dunn. I know they change in sound a little bit. You might think it was different guns firing the rounds. It's all Michael Dunn. So let's play that video again and pay attention to the last couple of seconds. Watch the difference in response and demeanor of these two women.
Oh my God, somebody's shooting. Somebody's shooting out their car. I swear to God.
Okay. Did you see the fiance staring out the window going, oh my God, someone's shooting. Oh my God. Standing upright, looking out the window. Like she's looking at a squirrel. Like it's a dog looking at a squirrel. You see the clerk? That clerk is hunkered down behind that counter. Which of those two women you think has a more prudent response to a gunfire happening a few feet away? You think that clerk seen gunfire in that convenience store parking lot before? Maybe. Or other similar situations in her life? Because if it were me, I'd be flat on that floor. I would not be doing the fiance bit. All right, so we have those shots. So let's step now through what those shots actually mean. The first three shots, the pop, 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 those were the shots fired at Jordan Davis, who Michael Dunn said was pointing a shotgun-like weapon at him. So here's a little schematic I created. Here's Michael Dunn's car in the bottom. Michael Dunn's the green circle. Jordan Davis is the red circle. He's in the rear passenger seat of this vehicle. And you can see the shots are angled a bit backwards. Dunn is kind of shooting over his left shoulder back at Jordan Davis. And this is where Jordan Davis would be shot and mortally wounded. And you can see, again, the three arrows here represent the three shots. And I actually have the forensics photos of the ballistic rods. These are long orange rods that are inserted through the holes made by the path of a bullet. So you can kind of visualize the path of the rounds. And here are here's the forensic photograph of those. So in the white circle here, the orange rods on the left, and they're almost perpendicular to the door. So Michael Dunn was obviously almost directly across from Jordan Davis. They were almost next to each other. This is the path of those bullets, largely perpendicular to the door. This is the seat in which Jordan Davis was sitting. He got struck by those bullets, mortally wounded. So those are the first 3 rounds. Pop, pop, pop. These are the killing rounds. These are the rounds that killed Jordan Davis. So these are the rounds that are the basis of the murder charge against Michael Dunn. Now, Michael Dunn would raise a self-defense, legal defense, to his use of deadly force here. He would say that Jordan Davis pointed a shotgun-like weapon at him. That's why he fired the 3 shots at Jordan Davis. So the question becomes, would the jury conclude ultimately that the state had disproven the claim of self-defense beyond a reasonable doubt with respect to these first 3 shots, the killing shots, when they considered the verdict on the murder charge? Does that make sense? So the first 3 shots were the killing shots. The question for the murder charge is, were those 3 shots legally justified? Did the state manage to or fail to disprove self-defense beyond a reasonable doubt with respect to these first 3 rounds? So after the first 3 rounds, after the pop, 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 almost immediately we have 4 more rounds. Just a second later, these rounds were fired as the SUV began to back out of that parking spot. So now the SUV is backing out, so it's moving backwards relative to Michael Dunn. He's shooting more over his shoulder now. So the angle of fire, because Michael Dunn's not moving, but the SUV is moving further behind him, the angle of the shots begins to steepen. Okay, that is this image. So now we have 4 more shots fired. Remember, the sequence was pop, 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 then a long pause, then 3 more rounds. We just covered the first pop, pop, pop. Now we have the second series of rounds, pop, 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 pop. These struck the front passenger side door. There's another young black man sitting in that seat. But these rounds didn't injure anyone. In fact, they were captured by the door. So again, in terms of terminal ballistics for a 9mm pistol, arguably because of the steeper angle, perhaps, they penetrated the outside surface of the door, but they did not penetrate into the passenger compartment. When the inside panel of the door, the interior panel on the door, was popped off, the expended bullets were found inside the door cavity. That's where they were recovered. Well, 3 of them were recovered there. One of the shots was never recovered. So we don't know where that went, except we do know that this dashed line back here on the left, there were a bunch of gas pumps back there, people gassing up their cars. So it's very, very fortunate that none of those innocent bystanders were struck by that errant 4th bullet. Now, no one was injured by these rounds, and for our purposes, I'm not going to discuss them any further, except to note that that's the 4 rounds fired immediately after the first 3. And then we get to the long pause. It's fully a 6-second pause. So you can literally count 1 1,000, 2 1,000, 3 1,000, 4 1,000, 5 1,000, 6 1,000 before you hear the next shot, which is another sequence of 3 shots. And during that 6-second pause, the SUV, which was backing up here, did kind of a J-turn behind Michael Dunn's car, backed up, and then drove off forwards away from the convenience store. And Michael Dunn got out of his car, took a knee, fired more rounds at that departing vehicle. And those last 3 rounds were the basis for the attempted murder charges against Michael Dunn. So let's take a look at the forensics there. Oh, by the way, the forensics for these, the 4 shots, I do have that image for you. Or do I? Yes, I do, but I have to open it up. Okay, so let me take care of that. It's really the same image I just showed you a moment before, but for purposes of being thorough, here we go. So here's the second series of 4 shots. Again, one of them was a clean miss, so who knows where it went. but 3 of them entered the front passenger side door. That's inside the white circle here, these 3 trajectory rods. Notice the change in angle from the other trajectory rods. The first 3 hits were perpendicular to the door, just about. These are now steeply angled to the door because the SUV is backing out, is further rearward from Michael Dunn than it was when the first few shots were fired. Then we have that long 6-second pause. And right now I'm going to just play that video for all of us again so we can hear the sequence one more time. So here we go. We'll hear pop, pop, pop. Very brief pause. Pop, 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 pop. That's the second series of shots. And then the long 6-second pause before we hear 3 more shots. So here we go.
Oh my God, somebody's shooting. Somebody's shooting out their car. I swear to God.
One, two, three. 1, 2, 3, 4. 1, 1,000. 2, 1,000. 3, 1,000. 4, 1,000. 5, 1,000. 6, 1,000.
Oh my God, somebody's shooting. Somebody's shooting out their car. I swear to God.
Okay, 3 shots, almost immediately 4 more shots, and then the last 3 shots. So what was the deal with the last 3 shots? Well, these were the shots fired by Michael Dunn as he kneeled in the parking lot at the SUV as it was driving away. And these are the shots. So again, one of them was a clean miss. I only have illustrated here the 3 that actually struck the SUV as it was fleeing. So 2 of them hit kind of low in the bumper, and they did not enter the passenger compartment. One of them entered the glass, the rear glass. And remember, there's 3 people in this vehicle unhit at this point, still fully alive human beings. Jordan Davis is still in the vehicle, but he's mortally wounded. So there's 3 people here still could potentially have been killed. This bullet, 3rd bullet here, entered the rear window, traversed the entire interior of the SUV at head height, hit the driver's visor, and fell onto the dashboard of the vehicle. That's where they would recover that round. And there's the green circle is Michael Dunn kneeling in the parking lot, firing these shots at the SUV as it fled. And here we can see the forensics, those trajectory rods again. So 2 of those rounds hit the rear bumper. One of them entered the glass here and traversed the entire vehicle at head height. Miraculously didn't hit anybody. But these last 3 rounds were the basis for the attempted 3 counts of attempted murder against Michael Dunn. So the first 3 rounds killed Jordan Davis, murder charge that he now has to justify as self-defense. The last 3 rounds didn't hit anybody, but the basis for attempted murder charges that Michael Dunn now has to justify as self-defense. So that's the issue for us. How self-defense as a legal defense was treated or perceived differently by the jury for the first 3 rounds and the last 3 rounds in this confrontation. So I think I have another slide to pull up to kind of share that with you, or at least I believe the legal outcomes of what happened. So again, the first burst of fire that kills Jordan Davis. That's the basis for the murder charge. The last burst of fire, another 3 rounds, could have killed the others in the vehicle. So that's the basis for the attempted murder charges against Michael Dunn. So murder charge because of the first 3 rounds, attempted murder charges because of the last 3 rounds. What did the jury do? Did it return not guilty verdicts on all of these? Did it return guilty verdicts on all of these? Or did it treat the murder charge based on the initial fire differently than the attempted murder charge based on the last fire? Well, the answer is the latter. It treated them differently. It did not treat them the same. So let me pull that up. So let's consider the attempted murder charges first. Those were the charges based on the last burst of fire. These were the shots fired at the SUV as it was driving away, and Michael Dunn claimed self-defense as his legal justification, which means that for the state to overcome self-defense, the state had to convince the jury beyond a reasonable doubt that they had disproven at least one of the required elements of self-defense. Now, this is Florida, famously or infamously a stand your ground state, so there's no element of avoidance. But there are the elements of innocence, imminence, proportionality, and reasonableness. So the state has to disprove one of those four elements beyond a reasonable doubt. And if they do so, self-defense fails as a legal justification for these charges, attempted murder, based on the third burst of fire. Or to rephrase the question, the jury has to ask ourselves, do we believe that that last burst of fire, those last 3 rounds, while the SUV was driving away, do we believe that was self-defense? And the answer was no. They didn't believe that. They believed the state had disproven self-defense for those last 3 rounds beyond a reasonable doubt because they convicted Michael Dunn on all 3 counts of attempted murder unanimously. So no question in their minds that those last 3 rounds were not legally justified. What about the murder charge? What about the charge based on the first 3 rounds? Did they convict on that charge? Or did they treat it the same as they did the last 3 rounds? And the answer is they did not. They treated it differently. The jury actually hung on the murder charge based on the first 3 rounds fired, which means at least one juror believed that the state had failed to disprove self-defense beyond a reasonable doubt with respect to the first 3 rounds fired, the killing shots that took the life of Jordan Davis. So what can we conclude from this? Well, we can conclude that the jury, at least one juror, decided, you know what, those first 3 rounds, I don't know. Maybe it was self-defense. It hasn't been disproven beyond a reasonable doubt. And unless self-defense has been disproven beyond a reasonable doubt, the judge is telling me I have to vote for acquittal. Now, obviously, not every juror believed that, because if it was unanimous for acquittal, it simply would have been an acquittal. But we know at least one juror was undecided because we have a hung jury on that charge. Now, Michael Dunn would be tried a second time on that one charge. The prosecution, if a charge results in a hung jury, the prosecution is free to retry the defendant on that hung charge, and the prosecution did in this particular case. But for purposes of this first trial, at least one juror believed that the first 3 rounds, the rounds that killed Jordan Davis, the rounds that were the basis of the murder charge, could have been lawful self-defense. But they didn't think that. None of them thought that for the last 3 rounds. So here we had we know that because they convicted on all 3 counts of attempted murder. So here we have a case where the first 3 rounds fired by Michael Dunn were arguably lawful. At least they had not been proven unlawful beyond a reasonable doubt to a unanimous jury. But the last 3 rounds, there we have a unanimous jury verdict of guilty, meaning that self-defense had been disproven beyond a reasonable doubt, meaning there was no justification for those last 3 rounds, even if there were legal justification for the first 3. So arguably, the first 3 rounds, that window of eminence might have been open then. And therefore, that first 3 rounds of force may have been legally justified. But once the SUV was driving away, that window of eminence had closed. And once it's closed, Michael Dunn no longer had a legal privilege to use deadly defensive force. And therefore, his firing 3 rounds at that departing SUV, the grounds for the attempted murder charges against him, his justification for firing those last 3 rounds, the jury concluded unanimously disproven beyond a reasonable doubt by the state. So let's go back now to the Houston shooting. I'll play that video real quick again. Here we go. So I actually see 2 shots fired there. 1 shot fired at the departing vehicle while it's still in close proximity. It's right beside the pickup truck. And then it makes a right turn at the corner, and it's further away. It's driving away, and the woman fires a second round as it's departing. Could either of those rounds be legally justified? Well, the possible justifications we're looking at here are self-defense, defense of others, or defense of property. This is Texas, so it's Houston. But even in Texas, that has Texas Penal Code 9.42, the deadly force in defense of property statute, there may be a rationale here. because you are allowed to use deadly force under certain circumstances if all the boxes are checked to prevent the loss of personal property, to prevent the personal property from being taken. So certainly if I were this woman's lawyer and property were at issue, that's a legal defense I would raise. I would note from this video that we have no reason to believe the people in that car had any of her property. Right? Well, we don't know that they stole anything from her. So you need some kind of piece of property in contention before you even have the defense of property argument. I don't know that we have any evidence to that effect here. But it could theoretically be a legal defense that's raised. Here's the problem. Any of these justification defenses are based on reasonableness. And I mentioned earlier at the start that this woman could well be facing a charge of felony reckless endangerment for especially firing that last shot after the car's turned a corner at some distance away. I mean, it doesn't even look like she's aiming. And there's a building with people in it in the path of that fired round. She's far more likely to hit that building and prospectively somebody in the building than she is to hit that car, one of those people in the car. Is that a reasonable use of force to prevent the loss of property? I would suggest it's not. Folks, if you have a 1 in a million chance of accomplishing your goal that you're trying to justify and a 1 in 1,000 chance of killing an innocent bystander, you're much more likely to end up with the wrong result. And that doesn't strike me as a reasonable solution to the problem of the loss of a piece of personal property. But certainly if these people in the car had stolen her property, that would be a legal defense that could be argued. In the other 49 states, though, had this occurred anywhere else, there's no provision for the use of deadly defensive force in defense of mere personal property. So then we're talking about defense of persons, could be the only justification. Defense of self or defense of others. Now, certainly, let's imagine that we don't know the precise nature of this confrontation between them. At least I don't know it. But let's pretend that the people in the car had guns of their own. They were threatening this woman with guns, even as they were still departing right next to the pickup truck. So the first shot she fires at them. Well, if someone's in a car pointing a gun at you, from 10 feet away, it's really no different than if they were just standing 10 feet away pointing a gun at you. Sure, you can use deadly defensive force to defend yourself, assuming the other conditions of the justification are met, the other elements of the justification are met. But even if they're armed with guns, once they turn that corner and they're driving away, how would you even know they're still pointing a gun at you? Or what's the prospects that you're likely to be hit by a round through the glass of that car as it's departing? I mean, once the car is driving away, it sure doesn't look like they're trying to engage her with any kind of fire. So self-defense may be credible. Maybe you can make that argument with a straight face when that other car is in close proximity. When it's 40, 50, 60 yards away, especially when balanced against the risk you're creating to others by kind of firing that shot so haphazardly. Defense of self is not a very compelling narrative here, especially for that last shot. What about defense of others? Well, that gets a little more complicated. So normally when we're talking defense of self, once we have a certain degree of distance between ourselves and the aggressor, we begin to see the defense of self justification diminish considerably. But long distance shots in defense of others are much more common because then it's not required that the aggressor be close to you. It matters that they're close to whoever it is they're threatening, or close enough to whoever they're threatening to present as an reasonably perceived imminent threat to that other person. We saw this in the mall shooting in Indiana, right? These shots, 8 out of 10 shots fired at 40 yards is the narrative. Your justification for shooting at someone 40 yards away would be more difficult if you were arguing defense of self. Could be possible, definitely. I mean, some guy's coming after you personally with a long gun. Sure, he might be 40 yards away, and you may not be able to wait for him to get closer before you can use your handgun in self-defense. Get it. But it's a much cleaner narrative if you're arguing, hey, I wasn't shooting at him because I was worried about me when he was 40 yards away. I was worried about him shooting the guy who was 5 feet from him, because that person's definitely in close enough proximity to be an imminent victim of deadly unlawful force. So I was firing at 40 yards to protect the person who was 5 feet away from the bad guy. And of course, we did have that, was it Waukesha? sorry, I struggle with the names sometimes. This was the incident where the apparent religious fanatic or racial fanatic drove a car through a parade of people. Obviously, he didn't need a gun. He was using his car as a weapon. Might someone have been justified at shooting at that car? So they see the car come racing past them at the crowd. And let's assume they had a reasonable perception that this was being done with the intent to drive through the crowd. The car goes past them. Now it's departing from them. Might they be justified in shooting at that car to prevent it from driving through the people in the parade? Well, I think you have a technical defense of others narrative there. Then the question becomes the balancing test. How sure are you that this is intentional and not someone who's a diabetic and has gone into insulin shock? In which case, shooting at them is not going to be helpful. How likely is it that you're actually going to get hits that neutralize that car from proceeding through the parade, as opposed to your bullets penetrating through the car or missing the car and you yourself shooting and striking people in the parade? Because then it's much like the scenario we talked about otherwise. If you're very likely to cause injury to innocent people and very unlikely to actually neutralize the threat just from a practical perspective, it doesn't sound like a reasonable justified use of force any longer. So can shooting at a fleeing car be lawful? It can, but the scenarios in which it would be become extremely narrow. Defense of self. I mean, if someone's driving away in a car and there's a passenger leaning out a window firing back at you, maybe. But absent the ongoing reasonable perception of a threat, the fact that they were trying to run you over before or pointed guns at you before or fired shots at you before, just like with Michael Dunn, doesn't mean that you still have a privilege to use deadly defensive force. You might have before when you were facing an imminent deadly force threat. That doesn't mean you still have that privilege once they're racing away. In defense of others, maybe you actually have, I would argue, a broader possibility of justification there, but you have to balance that against the risk you're creating to others by firing your gun in the general direction of that vehicle. And the defense of property scenario, I already kind of beat to death already. All right, so I think that's all I wanted to say about all of that. So I'm going to start going through the comments. Let's see. First, I'll start with the Law of Self-Defense members. And by the way, for those who might have missed the first few minutes, just earlier today, I signed a lease for new office space for Law of Self-Defense. So enjoy this background, folks. This is probably the last time you're ever going to see it in a live show. Plan to move in this weekend, and starting next week, we'll start having the new office background for your enjoyment. So we'll have to see what that looks like. Now we're talking interior decorating. That's not entirely up to me, but it'll definitely be different than what we see back here. All right, so the Law of Self-Defense chat room. Many thanks to Emily for fixing things. Yes, indeed. Thank you very much. Let's see. Right. So FB says, it would seem to me, for the same reason as for an officer, you could continue shooting at a fleeing shooter if they continued to present a threat to others. Yeah. So say you were engaging an active shooter, like the Indiana Mall shooting, and they were wandering through the mall in your direction, shooting people with their long gun. And you took them on the flyer with your handgun. They realized you were shooting at them, and they turned and ran away, but still in possession of their rifle. Well, you could argue that they're still an ongoing imminent deadly force threat to whatever innocent person they run into, and shooting at that person as they flee could arguably be legally justified as a defense of others situation. Now it changes if they drop their rifle, if they apparently, let's pretend we could magically know that they no longer have any weapons in their hands and they just start running away. If they're no longer an imminent threat to innocent people, even the police are not supposed to be using deadly force under those circumstances. Let's see. What else? I think that's it for the members. All right, so now I will go and take a look at the super chat questions. While I do that, while I pull that up, I will also pull up the free book offer from Law of Self-Defense. That is this book, folks. Law of Self-Defense Principles. It is a real book, not just some goofy PDF download. I know those things exist on the internet. A couple hundred pages, softcover book. If you get it at Amazon, and I encourage you to look for it there. It's got over 1,000 reviews, 5-star rated, but Amazon will charge you $25 plus shipping and handling. We will eat the $25 if you order it from us. We do ask you to still cover the shipping and handling, but we'll eat the cost of the book, and you can get that at lawofselfdefense.com/free book. And if you're not even willing to do this, to learn where the legal boundaries are for use of force to protect yourself, your family, and your property, you're just not a serious participant in the conversation, folks. So I would urge you to at least get this, our free book, lawofselfdefense.com/free book. Easy enough to remember. By the way, for those of you who prefer, we have a beautiful hardcover edition of the book. Looks great on a bookshelf. This one's not free. They cost us too much money to have printed up to make them available for free, but you can get them at lawofselfdefense.com/gethard. lawofselfdefense.com/gethard for the hardcover version of the book. Make great gifts. Great gifts. All right. So now let me pull up the super chat stuff, and we'll see what questions all of you have posted up here on today's show. A couple of these look like they might be from yesterday, but because we had a failure in yesterday's airing of the show. So let me see. Ricky Hendricks, $5 super chat. Thank you very much. I very much appreciate that. Writes, you said, he writes, but officer, he was not fleeing. He was repositioning himself for a more deadly attack. That could be, folks, but you can't just speculate that. There has to be evidence from which you can make that conclusion. So you're dealing with an active shooter, for example, and he ducks behind a column in the mall. Is that flight, or is he just ducking back there for cover while he's loading his gun? I think you could make a reasonable argument that it's not flight. He's not actually in flight. But if he's dropped his gun and he's just running down the mall, then he's not simply repositioning himself behind cover. I'm not telling you what to conclude. You have to draw your conclusions from the evidence, but you can't just pretend what you're seeing. Your perceptions, your decisions, your actions in use of force have to be reasonable, meaning based on the application of your powers of reason to actual evidence. You've all heard that if you ever use force against someone, you have to be able to articulate why. And that's true. You do need to be able to do that. But articulation in the legal sense doesn't just mean come up with some story. It means come up with a story that's the result of the powers, the application of your powers of reason to actual evidence. In evidence-free articulation is worthless. Another from Ricky Hendricks. I think from yesterday, $20. Very nice. Much appreciated. One ka-ching for each $5 increment. Ricky says, you said if Eli had shot an innocent, he'd not be charged because of going after the bad guy. But I asked if good guy had a shot. If good guy had shot bad guy in department store and hit girl in dressing room, you said good guy would be charged. Would you clarify? Yes. So I never speak in absolutes. So I wouldn't say that Elisha Dickens in Indiana would not be charged for hitting an innocent. It's up to the prosecutor if they want to charge. I think on the legal merits, he has a very strong legal defense on the facts of his particular case, that he was using defensive force reasonably, non-recklessly, because he got 8 out of 10 hits. That's pretty darn good, better than most law enforcement in actual shootings by far. And so if you're using that defensive force non-recklessly, reasonably, then if an innocent bystander gets hurt, it's just it's an act of God, essentially. It's a genuine legal accident for which there ought be no criminal liability. It's never the case that you can't be charged, that you can't be prosecuted, that you can't be convicted. I don't talk in those terms because any of those things could happen. You could be the most innocent person in the world and be charged, prosecuted, and convicted. But on the legal merits, it ought not be the result. The same with the shooting. This was a shooting that took place in, I forget the store, but it was like a Target kind of place. Some lunatic was stabbing at people with an edged weapon, if I recall correctly, and the responding officers fired a shot at him, missed, and the round went on to penetrate a wall and strike and kill a young girl in the changing room. The officers didn't even know she was there, probably didn't know there was a changing room there. And at the time, I probably suggested that on the merits, there was little likelihood that officer would be charged for the same reasons. They were acting non-recklessly and reasonably, and their good intent carries with the bullet. Now, if either Elisha Dickens in Indiana or the police in that Target store, or whatever it was, had been acting recklessly, that's a degree of criminal intent. Recklessness carries criminal liability. Then that reckless intent would also carry with their bullet the bad intent, and they would arguably be legally liable, ought to be legally liable for the innocents that were struck by their rounds. Here's Evil Bunny, $20 super chat. Thank you so much. Writes, I am Evil Bunny from somewhere, and Bunny. All right, Evil Bunny. And then another one from Evil Bunny. All right, another $10. Writes, I am enjoying reading your book. It's easy to read, super informative, and I'm marking it up like a college textbook. That's what everyone should do, folks. Do not read this book like the romance novel it's intended to be. Read it like a textbook. Highlighter. Make notes in the margins. Date sections. If you ever hope to use the knowledge you acquire from this book in your legal defense, ladies and gentlemen of the jury, what my client did was reasonable because he knew this stuff. Then you need to be able to document that you knew it at the time of the event, the use of force event. And a great way to make sure you have that documentation is to use this as a textbook. Mark it up accordingly. Evil Bunny there, booty comment in chat you can't ignore. Joking. So actually, the enjoying reading your book was not from Evil Bunny. It was from Mexican Iron Man, $10 super chat. Mexican Iron Man is the one who wrote, I'm enjoying reading your book. It's easy to read, super informative. I'm marking it up like a college textbook. Everyone should buy your book. Mike from South Carolina. Thank you very much, Mike. That is very much appreciated. Marcus Dufour, $20 Canadian, whatever that might be worth, but I'll pretend it's US dollars for purposes of the ka-ching. For self-defense, if you take a person down and can control them using wrestling, judo, Brazilian jiu-jitsu, the window would close. But if the person then drew a knife or gun, it now opens again for deadly force. That could be the case, right? So you can imagine a situation in which a person is attacking you, they pull out a knife, and imagine you, so when they're wielding the knife in close proximity, they present as an imminent deadly force threat. And then let's pretend you karate kick the knife out of their hand. Now they no longer have the knife. So arguably, they're no longer presenting as an imminent deadly force threat until they pull a second knife out with their other hand. And now they're again a imminent deadly force threat. So yes, fighting is fluid, and the conditions that are triggered can vary over the course of the fight, including in this way. Mike Sullivan, $50 super chat. Mike, I don't know if I have 10 of these ka-chings in me. I might not be able to keep count for 10. Well, that's 5, 6, 7, 8, 9, 10. $50 super chat from Mike Sullivan. I'm going to have to come up with some combination like, yeah, that sounds pretty good. I think that's what I'll do in the future for the larger super chats. Mike writes, I'm former LE, current concealed weapon permit firearms instructor. Mr. Branca's content is absolutely spot on. I tell all my students about the book, channel, program. Folks, let's show this gent the respect he so richly deserves. Fill the tip jar. And folks, I don't want to diminish how grateful I am for the super chats and the tip jar and all that. That's not actually our business model. I use the super chats mostly as a way to prioritize the comments for me to answer in question form. Otherwise, there would be way too many comments in the chat for me to address. But unlike many of the law tubers, our business model is not to make money off YouTube. For all I know, YouTube cancels my channel tomorrow, so it's not something I'd be comfortable, making my mortgage depend on. Our business model, besides, of course, our legal services, are things like the book. You can get lawselfdefense.com/free book. Our courses, our full day law self-defense advanced course, and the other stuff that we make available, including our platinum membership, which is the only way to have me provide a legal consult on your use of force case if you're ever involved in a use of force event and find yourself criminally charged. Learn more about becoming a Law Self-Defense Platinum member at lawselfdefense.com/platinum. If you're not a platinum member at the time of the use of force event and you call my office, we cannot help you. We will not help you because we just don't have the bandwidth. So we only provide legal consults to people who are Law Self-Defense Platinum members at the time they're involved in their use of force event. And again, you can learn more about being a platinum member at lawselfdefense.com/platinum. STFU FFS $2 super chat. Well, I don't have a half a ka-ching. So from Waukesha. All right, that's enough for me. STFU FFS, another super chat. Which do you prefer, locals or YouTube membership? Another $2. Again, YouTube is not really our business model. I don't honestly really know how the YouTube membership works. I know we set it up, and I think you pay some money to be a member, and YouTube, I think, keeps a third of that and gives the rest to us. But honestly, that YouTube membership money, if all you do is hit the subscribe button, hit the like, thumbs up, and leave a comment, I'm eternally grateful. Don't feel obliged to also become a member on YouTube and send YouTube more money. If it comes to that, listen, rather than all of that, if you want to recommend to your friends and family that they get a copy of the free book, lawselfdefense.com/free book, that's worth that. That's much more favorable to me than you sending a third of whatever you're giving me straight to YouTube. The bastards. All right, let me do a quick refresh here and see if we have any more super chats. We do. We have a couple more. All right. Crossbow Sniper, $5 super chat. Thank you. Is there any time where the body cam I wear could be used against me, even though I am not the aggressor and I'm acting in self-defense? So, folks, here's the bottom line. With body cameras or dash cam videos or ring videos or other people recording you with their phones, generally speaking, good guy cases of self-defense, you want more evidence. Generally speaking, good guy cases of self-defense, especially people who know what they're doing, who know where the legal boundaries are, their claims of self-defense don't tend to get into trouble because there's too much evidence in the case. They tend to get into trouble when there's too little evidence in the case, and the evidence begins, the argument, the claim of self-defense begins to look speculative or imaginary. Generally speaking, more evidence is good for us. So generally speaking, if you had body camera footage, it would be good for you. Generally speaking. But if you screwed up, if you did something wrong, that also gets captured on video. So is the video helpful to you? If you did things right, it's helpful to you. So for God's sakes, learn how to do things right. If you do things wrong, it's going to be incriminating. So don't do that. I don't know what else to tell you. I can't magically turn a bad shoot into a good shoot. That's up to you. You have to make sure your use of force is within the legal boundaries. All I can do is help inform you on where those legal boundaries are. And I would encourage you to start developing now your kind of default tactical responses to prospective attack ahead of time, and knowingly within the constraints on use of force, so that when you are scared and you default to a defensive response, it's one that's pre-programmed to be within the legal boundaries. That would be my advice from a tactical perspective. Mike Sullivan, $5 super chat. Thank you, Mike. Writes, you mentioned your background. If my old eyes are correct, are you a Flying Dutchman? I'm not sure what that means, a Flying Dutchman. My mother was Belgian, which is almost Dutch. Not really, but close, pretty close. Spoke Flemish as a kid. I did, which is almost Dutch, not quite Dutch, but pretty close. Other than that, I'm not sure exactly what you have in mind by Flying Dutchman. I do have a beer stein back there. It's from BMW. I got it with one of my motorcycles. And it looks like the last super chat from First Last, $20. Very nice. Very much appreciated. First Last writes, finally caught you for live, barely. Going to go back and watch the beginning now. All right. Thank you very much. If you're asking about the large painting over my shoulder, this shoulder here, that is a print on canvas of Washington crossing the Delaware. One of my favorites. I have other paintings here. I have the battle on Concord Green up here, but that's outside of camera view. Of course, I have the Constitution. I have the Declaration of Independence. I have my law degree, a couple of IDPA plaques, and my certificate from Jeff Cooper's class, my certificate from Asa Youb's class. My other hand up here is one of our, I forget if it's a copyright or trademark certificate for, sorry, I forget. What else? Up here, for Science Institute degree, and below that, a little promotional pamphlet from one of the times I spoke at the FBI Academy down at Quantico and all that. I don't know. All this has to be reorganized now for my new office space. Starting next week, folks, you'll see me in my new office. So we'll have to see what that looks like. Yeah, I don't think Biden was in the boat with Washington. I mean, he's old enough. But I'm pretty sure he would not have met their standards, to say the very least. All right, folks, I think that's all I have for all of you today. So with that said, I will remind all of you that if you carry a gun so that you're hard to kill, that's certainly why I carry a gun, so I'm hard to kill. So my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. Until next time, probably Monday. Maybe we'll do something over the weekend. We'll see. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.